All right, good afternoon, everyone. It is what 10 till 2. It's on Tuesday, February 16th, 2021. Welcome to the Judicial Proceedings Committee. Today we have 8 bills on the docket. So we'll start off with Senate Bill 569. And I see that Mr. Castley, the other one, is here with us. And he'll start off. But before I hand it over to Mr. Castley, we will go with 569 and then we'll head off to 648, 501, 501, 586, 519, 531, 553, and then we'll end up with the other Castley, 495. So with that, we'll turn it over to Mr. Castley with Senate Bill 569. The floor is yours.
Good afternoon, Chairman Smith, Vice Chair Waltrester, and esteemed members of the Judicial Proceedings Committee. For the record, my name is Andrew Castley, Senior Advisor in Governor Hogan's Legislative Office. I come to you before you today to present Senate Bill 569, and joining me on my virtual panel will be Ms. Chrissy Nizer, Administrator of the Maryland Motor Vehicle Administration. Senate Bill, ladies and gentlemen, Senate Bill 569 will enact several customer service-oriented reforms that will increase the efficiency and streamline customer service at the Maryland Motor Vehicle Administration. Essentially, in other words, this bill will greatly reduce the amount of time each one of the committee members stands in line at the MVA. So with that, I'm going to turn it over to Administrator Nizer to explain how that works.
Thank you, Andrew, Mr. Chairman, and Mr. Vice Chair, members of the committee. Thank you for having me here today. For the record, my name is Chrissy Nizer, MBA Administrator, and we like to think that with our appointment system, you're not waiting in line too long. But that being said, we are all about efficiency and making a better customer experience. I'll walk through the provisions of the bill and explain exactly what we're trying to accomplish. The first provision would just mirror what we already have for driver's licenses, where you can get 2 45-day products, and that helps people who maybe come up for renewal, need that real ID and don't have all their documents. We don't currently have anything to help people that have ID cards in that exact same situation. We know many of our elderly get an ID card as opposed to a license, and we want to be able to assist them in issuing the 2 45-day temporary licenses. So we think that's a good customer service provision. The second is related to truancy and the requirement that was passed into law by the legislature a few years ago. The law currently requires to have that paper form that's actually certified by the school. We're not touching the provision, and the requirement will still be in place for those getting a learner's permit before the age of 16. But we want to allow that to be sent to us electronically from the schools. Obviously, with COVID, schools being shut down, and just advances in technology, we know we can make the process a lot easier for everybody. The next provision is related to that vision requirement. So for those of you over the age of 40, myself included, we have to get that vision test every time before we renew. Right now in the law, it's written that that test has to be 12 months before you take that renewal action. We want to increase that to 2 years. We now have the ability to electronically accept vision results from our eye providers throughout the state. They send it in electronically whenever you get your test done. And that record is on file with us, so we can go ahead and renew that license again without you coming into the branch office, and take care of that in a very expedient manner. The next provision is related to when you can renew your license. Currently, you're not allowed to renew before 6 months prior to that expiration date. In the past, we've seen challenges with folks that are in the military or maybe out of state who need to renew and maybe here 8 months before the renewal date, but not during that time period. This would extend the time you can renew to 12 months before that expiration date. Right now, that also helps us with Real ID. As you know, the new deadline's October 1 of 2021. This would allow another 60,000 people to be able to renew their license without having to pay for a $20 duplicate and then come in 6 months later and get their license renewed. It just doesn't make any sense. If we extend that renewal period to 12 months, that'll allow a whole nother category of folks to be able to take advantage of renewing the license and not paying that additional fee. The last provision is related to your photo. The way the statute is currently drafted is that you have to have that photo taken every other renewal period. As you know, we have an 8-year renewal period. The way the federal requirement is, you have to have one photo every 16 years. And what we're trying to do is essentially align our requirement with what is set out in federal law. And the reason for that is because you may come in outside of your renewal time. Say you move and you want to come in, or you lost your license and need to come and get that duplicate. Even if you came in 2 years before, if your last renewal and got that photo taken, the way the statute currently reads is if your last renewal was done, outside the branch, you would be required to come in again, which really doesn't make any sense in terms of the photo capture because we already have an up-to-date photo for you. Again, many of these provisions were either customer feedback or employee-driven ideas, and we really think they all add to efficiency and great customer service, which is what we're all about. With that being said, I would urge the committee's favorable report on Senate Bill 291 and be happy to answer any questions you might have.
Excellent. Thank you, Administrator Neiser. Looking around the room for questions. Seeing none. With that, that will conclude the testimony for Senate Bill 569. Thank you both. Good to see you both.
Here.
Excellent. So next we will have Senator Carter, Senate Bill 648. Senator Carter, you are, hold on. The screens are moving around too fast. All right. Sorry about that, Senator West. Your screen was where Senator Carter's was, so that's why I did that. All right, Senator Carter, you're up.
Thanks, Chairman Smith and committee. I will do my best to be as efficient as the previous bill to the extent possible. Senate Bill 648 is a bill that would allow for primarily towing companies, but others, to be able to sell abandoned vehicles at public auction. Currently, towing companies are restricted for only being able to have these vehicles, sell them as parts, but not actually, in full-fledged vehicles. So what the request is that they would be able to remove this statutory limitation and allow them to act as actual sellers. Currently, law enforcement is only allowed to do it. And if we were to remove this one restriction, all of the same safeguards that exist in current law would still be in place, meaning I looked at the Attorney General's letter, and I think it's unfounded because there would be no restriction lifted in terms of allowing people or towing companies or anyone to be able to sell vehicles where all of the proper notifications and requirements were in place. What's the reason that we want to do the bill? One, towing companies currently bear all of the costs and responsibilities for towing and storage, notification, insurance to owners, insurance companies, and potential lien holders. But at the end of the whole process, they receive no compensation even for their efforts. And so this is a small step in the direction of helping them out. I'm pleased to have as my lead witness the Councilman Ryan Dorsey, and also Charles Parrish from Vision Record Service, Inc., and Paula Pratani from Frankfurt Towing. And following their testimony, we'd be happy to answer any questions.
Excellent. Thank you, Senator Carter. And we'll now have the Councilmember Ryan Dorsey. Councilman Dorsey, you're up next. You're the primary witness. You'll have 5 minutes. Good to see you.
Thank you, Mr. Chair. Thank you, members of the committee. It's always a pleasure to be here with you. I want to thank Senator Carter for working with me to put this bill forth. It came from just listening and listening and listening to towers. Why do I listen to towers so much? I'm a member of the City Council, and I'm the Council's representative member of the city's Trespass Towing Board. In this capacity, I've learned more about towing than I ever wanted. But along the way, I've become familiar and interested in the nuances of both the state and local law. If anybody in the city has any question or problem related to towing, I'm the guy they come to. And in fact, just last week, the City Council had a hearing on a bill idea that came to me from questions from your colleague, Senator Hayes, and I'm glad that that bill was passed out of committee. Before I go further, I do want to touch on the policy note and the Attorney General's letter of opposition and take responsibility for, having worked with DLS and Senator Carter's staff on the drafting of this bill as an oversight in the way that it was drafted, basically to open it up to anybody with a vehicle abandoned on their property. The intent is for this privilege to sell through public auction to be limited only to trespass towers, but which I think is important to note is not defined in the state code, which I think is probably part of the reason why we incurred this oversight. Trespass towing is not defined in the state code. It is rather only referred to descriptively as persons engaged in the business of towing from private lots. So I just asked for some consideration of that and state that I believe that the bill should be amended to specify that it should only apply to that group of people. As Senator Carter stated, when a trespass tower removes a vehicle from a private lot with whom they are contracted to do so, the tower incurs a cost for this service. They're only ever compensated for this act of towing when or if the vehicle is reclaimed by its owner or a lien holder. Until then, additional costs are incurred to operate the tower's storage facility 24/7, to provide certified mail notification per the state law, and to keep the vehicle for a minimum of 45 days before the tower may even apply to be able to dispose of the vehicle, at which point the state provides them exactly one option: to literally give the vehicle away to a junkyard and recoup none of their incurred expenses. This happens somewhere in the ballpark of 25% of the time. I don't know how many businesses operate on a similar basis where they're only going to get paid for 75% of their direct services, but understanding the circumstance made it easy for me to understand why it costs so much to get your car back when it's been towed. And that's where I really come from with this. The tower has to make up for that loss somewhere, and it ends up being on the backs of everybody else. I don't want anybody to get charged more than is necessary. And while the state authorizes local jurisdictions to set maximum fees, it's hard to do that when you're looking at the difficulty of the situation the state places the trespass towers in, limiting their ability to recoup on their efforts. The state doesn't say that they can't get rid of the vehicle, and in fact sets up an effective control to protect against bad actors, requiring that a certificate be provided by a police department in order to authorize them to dispose of the vehicle. This same exact protection would still apply and remain in effect if the towers were also able to dispose of the vehicles through public auction, just like local governments are allowed to do. But this would allow them to recover costs, even in many cases, if it was just a portion of the costs, instead of being limited to having to literally just give the vehicle to a junkyard. Some of the owners and some of the larger trespass towing companies happen to also own separate automotive dismantling and recycling companies, junkyards, which are required to be separate entities and have separate facilities for vehicle storage. But this really is not an option for many of the smaller companies, many of whom are Black owned, and many of whom employ ex-offenders and individuals who might otherwise find difficulty attaining employment. And we don't really need all of those small companies adding to our land use of junkyards anyway. What this bill is asking for is to afford these small companies a reasonable ability to recoup on their investment, on which they will not become rich. Like, nobody's going to the bank on this. And there are sufficient regulations already in place to protect against harm to vehicle owners.
Time.
And so it just seems reasonable that this provision that I think just goes beyond serving the public's interest be this constraint that goes beyond the public interest be withdrawn and allow trespass towers the same opportunity as we already afford to local governments.
Excellent. Thank you, council member. Always good to see you. All right, next. Thank you. Next, we'll have Mr. Parrish. You're up next. I see you down there.
Good afternoon. Can you hear me?
Yes, we can.
Oh, good afternoon. Charles Parrish, Vision Record Service. Been an active trespass tower in the Baltimore metropolitan area for 30 plus years. I'm also, for the last 18 years, been on the legislative and presently the chairman for trespass towing through the Towing Recovery Professionals of Maryland, TRPM known. And I apologize for the background. I'm in my vehicle. I'm actually out on the road today. Senator Carter and the Councilman Ryan Dorsey couldn't have said it any better. I don't want to I'll do a me too with that. And it is helping the small towers. Like I said, I've been doing this for 31 years. Our notification process is the same as the police departments. They are the same as the ADRs. We actually are even a little bit more stricter because we have a hands-on by the local police departments. So getting this bill would take a lot of our overhead that we do get stuck with, that, as Mr. Dorsey said, does go to those who end up paying for their vehicle. It could help us lower those fees because 25% is very accurate across our industry. We get stuck with these vehicles. And the CS78 that you're talking about says we have to transfer. We're not allowed to sell it. It's through a transfer, even though we do all the same notifications. So any help with this, I would deeply appreciate. And like I said, I do a me too behind Councilman Dorsey.
Excellent. Thank you, Mr. Parrish. Thank you for taking the time to testify. Glad to see you're parked and strapped in. Believe it or not, we had someone driving and zooming this summer. So glad to see you're parked and safe. Thank you very much. All right, so then we'll move on to our final witness for the panel, and I think it's Ms. Protani. You're here. You're up next. Ms. Protani, I think you're unmuted and ready to go whenever you are. All right, we will attempt to reach her on the back end and move on. Thank you, Ms. Protani, but so we'll loop back with you. So with that, that concludes the panel for Senator Carter. And if we can, Senator Carter, you've got your hand raised. Go ahead. Hold on, you're unmuted. There you go.
Thank you, Mr. Chair. I'm sorry that we couldn't hear from Ms. Protani, who's another tower that would attest to how this would help the business. My question was going to be for our members of the panel that are in the towing business, which is a question that we all would like to know on behalf of our constituencies. Is if this bill were to pass, is there a possibility that you could lower the fees that you charge for tows?
Very good question. All right, Mr. Parrish, I'll unmute you, and then Paul, if you can hear us and you can chime in, please do.
I'm sorry, but the question from the senator: would we be willing to lower our fees?
Yes, sir. Well, I said, was there a possibility? I didn't actually put you that much on the spot. I didn't say would do it. I said, is there a possibility that this would make it easier for you to do that? Is that correct?
Yeah, that's yes. Very much. It would definitely make it easier for us to do it.
And Councilman Dorsey can hold you accountable to that.
He already does.
Yeah, look, it's a strange day when I'm testifying on the same side of an issue with the towers. They're upset with me, because I do push on the fees, and they have lowered their fees in Baltimore City in the last 4 years, twice since I've been on the council and serving on this trespass towing board. Many of the towers were charging as much as $420 or $440 for a vehicle that they were towing from a private lot. And in 2018, we basically, the board pushed them to lower it to $350. And then just recently, and much less to their pleasure, I pushed in a certain way and got them lowered to $300. That's still a lot of money. That's a lot of money for people, particularly in Baltimore City. And I'd like to see that lowered further, and I'd like to make that a little bit more possible, a little bit more feasible, affordable for these companies to do that and still be able to provide the service that they do.
Excellent. Thank you all very much. Ms. Bertani, sorry we couldn't make it work out, but with that, that'll conclude the hearing and the testimony for Senator Carter's Senate Bill 648. Thank you all very much. Good to see you all.
Thank you, Mr.
Thank
Chair.
you.
Thank you. Thank you.
Next, we'll move on to Senator Bidle. I see you're here. Welcome with Senate Bill 586. The floor is yours.
Okay. Thank you, Mr. Chairman. I'm trying to bring my document over. Okay, I'll do it this way. Thank you, Chairman Smith, Vice Chairman Wallstreicher, and members of the Judicial Proceedings Committee for hearing Senate Bill 586. Senate Bill 586 simply takes the current legislation for the exemption on vehicle inspections from the age of 70 back to the age of 65, so that folks that are 65 and older and drive 10,000 miles a year or less would not be subject to have a vehicle emission. Thank you for your consideration of Senate Bill 586, and I urge the committee to move this bill with a favorable report.
Excellent. So let me see. Do you have, I think that was it for that? Okay. And then, so we'll move on to Senate Bill 501, Senator Bidle.
Thank you again, Mr. Chairman Smith and Vice Chairman Wallstreicher, members of the Judicial Proceedings Committee. Senate Bill 501 is a towing bill, imagine that, but it's really about the placement of signs in parking lots. So last year, apparently a bill was passed that required a sign every 7,500 square feet for large parking lots like regional malls that would just create sign litter, all over the parking lot. And so I have 3 regional malls in my district or in my county, and they've all requested that they be able to put their signs at the entrances to every parking area, not every 7,500 square feet. The bill will be limited to regional malls of at least 400,000 square feet with at least 2 anchor stores, and just require, again, the signage placement at each entrance to the mall parking areas as described the towing and vehicle policy. Thank you for your consideration on Senate Bill 501. And I urge the committee to move this bill with a favorable report.
Excellent. Thank you, Senator Bidle. And I know you have 2 panelists. Mr. Condon, you are the primary witness, so you'll have 5 minutes.
Thank you, Mr. Chairman, and thank you, Senator Bidle. As you heard, this current bill does require 1 sign for every 7,500 square feet of parking within a shopping center or any location. For a regional mall, that requires hundreds and hundreds and hundreds of signs. Simply put, our malls weren't designed for that level of signage, and would result in signs being placed throughout the parking lots on poles in the middle of asphalt. This would create not only obstacles for customers who are traveling around the shopping centers, especially at night, but also interfere with the operations of the centers during snow removal activities or even the nightly parking sweeping activities. At many lots where businesses are not manned 24 hours a day and where lots are accessible from multiple areas, this language, 7,500 square feet per sign, is meaningful, and it makes sense. But for regional malls, as you probably understand, it's not as simple, and it's a little bit more cumbersome, and candidly not necessary at most of these malls where access is limited to only a few areas. Speaking specifically of Arundel Mills, the center has 4 main entrances to the parking lot and 10 additional entrances where customers can drive onto the property through the businesses that abut the shopping center. With millions of square feet of parking, we'd be required to install close to 500 signs just to have this ordinance or this law upheld. That's it. One final thought, in today's retail environment, the last thing that any shopping center wants to do is tow a vehicle. It's the last thing that we want to do. Our customers are important to us. They have other choices, and we need to make sure their experience is as positive as possible. to ensure the success of the shopping centers and ensure the employment of all the thousands of employees that work in the regional malls throughout the state. So I appreciate Senator Bidle bringing this bill forward, and I ask for your support. Happy to answer any questions.
Well, thank you very much. And next we have Mr. Stavropoulos. You are up next.
Thank you, Mr. Chairman. Nice to meet you guys. Thank you so much for having me. Speaking on behalf of Westfield Annapolis, I'm the general manager. Westfield Annapolis has several million square feet of parking at the center, with the current code requiring one sign for every 7,500 square feet of parking area. We would have to install over 400 signs throughout our lots to maintain compliance. This is not only costly, is it also an operational expense, as we would have to identify over 400 locations without overstimulating our visitors with signage, and as Mr. Condon indicated, without creating a snow potential barricade for our contractors. Most importantly, it just doesn't make sense for a center of our size. The proposed revision would ensure the integrity of the legislation remained intact, as only regional mall complexes of not less than 400,000 square feet of gross leasable area and not less than 2 anchor stores remain compliant, and not burdening the large flagship properties with the larger footprint. At Westfield Annapolis, there's a no towing policy. We only allow towing once we have exhausted every possible avenue and approved by a member of center management. If not passed, the only outcome for Westfield Annapolis will be the center assuming considerable expense. So regardless, we will not continue to tow. And as Mr. Condon indicated, the last thing we want to do is upset our valuable customers. Thank you.
Excellent, thank you. And with that, that'll conclude the testimony for Senate Bill 501. Turn to the committee for questions. Seeing none, that concludes the hearing for Senate Bill 501. Thank you, Senator Bidle.
Thank you, Mr. Chairman.
Have a good one.
You too.
Next, I see that Senator Klossmeyer is here, so we'll go on to Senate Bill 519. Senator Klossmeyer, you are up. I'm going to ask there you go.
Oh, okay. Senate Bill 519 allows the wills to be self-proving with the use of a notary. While the bill is drafted to address advanced medical directives as well, significant concerns have been raised about medical directive section, so I will be putting forward an amendment to eliminate that section. Passing this legislation will put Maryland in line with 44 other states with the option to have a will notarized. Under current law, wills require 2 witnesses in order for a will to be executed upon the death of the testator. Should a will be challenged in court, these 2 witnesses must be found and testify that they indeed witnessed the signing of the will. By having the will notarized, it eliminates the process of finding these 2 individuals because the will has been self-proven. This will make it much tougher for self-proved wills to be contested in the court or accused of being fraudulent. I thank the committee for their consideration of Senate Bill 519, and I ask for a favorable report.
Excellent. Thank you, Senator Klossmeyer. You have no witnesses on your panel, so that'll conclude the testimony for Senate Bill 519. I'll turn to the committee for questions.
Asking me questions.
Here you go. Senator West has a question. I'll ask to unmute you. There you go.
There we go. Thank you, Mr. Chair. Senator Klossmeyer, always good to see you. I just have one question. Has this bill been viewed by the members of the Maryland State Bar Association's Estates and Trust section?
Yes.
I don't see them here testifying in favor of it. Did they have a problem with it?
No.
Oh, okay.
Yes, they just figured I was good enough to convince you that this is the best bill ever.
They don't have as much confidence in me. I think they're going to testify in what I'm presenting next week.
No.
Thank you.
They just declined to do that. Do you need a letter? Would you like a letter or something from them?
No, as long as they've taken a look at it and have no problem with it, I don't have a problem.
Okay. Yeah, no, we have.
Okay, good.
All right, excellent. And with that, that'll conclude the hearing for Senate Bill 519. Thank you, Senator Klossmeyer. Good to see you.
Okay, thank you so much.
So, all right, I don't see Chair Kelly is not here, but I do see Senator Young logging on. So Senator Young, if you can hear us, you're next with Senate Bill 553. See, your audio is still connecting.
It doesn't appear that Senator Young has speaker capabilities.
Excellent.
So let me give him a call to see if we can fix that. Do you want to go ahead and move on to Senator?
Go to Kathleen.
Yeah.
Okay. Senator Kathleen, are you ready to go?
I will be.
Okay, great.
Ready.
We'll move on to you next then. Until we
Okay.
get-
I don't know if Mr. Schellenberger, I think, is signed up. Is he out there anywhere?
I know he's not in the room, but I'm looking in the waiting room. Let me check.
He's not in either, and he was signed up to file another bill, so he wasn't in for that one either.
Actually, Senator Castley, guess what? I think Senator Young is, he may be up with his capability. So just to buy you some more time with Mr. Schellenberger, we can go to Senator Young
Okay.
and Senator Kelly if you'd like. All right, Senator Young, I'm going to ask to unmute you. Are you ready to go? Can you hear us?
Ready to go.
Excellent. All right, Senator Young, you're up with Senate Bill 553.
Okay, thank you, Mr. Chairman, members of the committee. This should be one of the easiest bills you've heard. It's Senate Bill 533, and it's Don't Block the Box bill. This is a bill that's passed the House the last 4 sessions, and it gives law enforcement the authority to enforce not blocking the intersection. In other words, if you come to a traffic light, unless you can clear the intersection, don't go through it. In big cities, people pull through, block the intersection, and the traffic can't go the other way. It happens many places. This, to me, is a common sense thing that I thought already existed, but evidently it's not in law. As I said, it's common sense, and it's proven successful in DC and Florida, Georgia, New York, Connecticut, Massachusetts, Rhode Island, several other places. Passing the bill makes the roads safer and more efficient in that you're not blocking traffic up. It's a no point violation and a $90 fine. Some people were concerned about their driving records and whatever, but it's no points and a $90 fine. And that's it. The bill's that simple. I would certainly appreciate you considering it favorably, and I'll take any questions.
Excellent. Thank you very much. So no witnesses. This will go to the committee, and I see that Senator West has a question. So Senator West, you're up.
Mr. Chair. So I think this bill is great, but I'm looking at the 4th page of the bill, and it says that a police officer cannot issue a citation for a violation unless the approach to the intersection has signs installed that notify the public that that you got to obey this law. We don't require signs to be installed all over the place about our other traffic laws. If this becomes the law of Maryland, why would we require signs to be set up prior to particular intersections? Shouldn't this just be an across-the-board rule?
Frankly, I have no objection if you take that out.
Okay, because otherwise it's going to require a lot of signs to be.
It is going to require a lot of signs, and it's true. We have right turn, left turn signs. I don't know that we need to clutter up that much more. As I said, I think most people think they're not supposed to do that now, but unfortunately it's the few that don't that cause the problem. But I have no problem taking that out.
Great, thank you.
All right, excellent. Thank you, Senator West. Looking around the room for additional questions, seeing none. Thank you, Senator Young. And with that, that'll conclude the hearing for Senate Bill 553. Thank you very much.
All right, thank you.
So I see Chair Kelly is here, so we'll take her next. Senate Bill 531. Chair Kelly, you're up.
Thank you very much, Mr. Chairman and members of the Judicial Proceedings Committee. According to the Sentencing Project, more than 2,500 individuals in the United States are serving a life without the possibility of parole for offenses committed before their 18th birthday. In recent groundbreaking rulings, the U.S. Supreme Court has held that certain common U.S. sentences meted out to certain juvenile defendants are actually unconstitutional. In Roper v. Simmons, 2005, the U.S. Supreme Court abolished the death penalty for juvenile offenders in cases where there is no conviction for homicide. In Graham v. Florida, 2010, the U.S. Supreme Court abolished life without parole for children not convicted of a homicide. And in Miller v. Alabama, 2012, the U.S. Supreme Court held that the sentence of life without parole is unconstitutional for a juvenile defendant if the sentence is mandatory, so that there is no judicial discretion. In its support for the ruling in Miller v. Alabama, the Supreme Court cites validated and peer-reviewed literature from the neurobiology field that indicates children are less culpable for their criminal offenses than adults because the brain of a juvenile is not as fully developed as an adult's. Therefore, children are less rational, more impulsive in their decision-making. The court also opined that juveniles are often powerless to extract themselves from criminal and/or abusive environments and succumb to peer and family pressures more easily. Additionally, they express concern that many juvenile offenders are themselves victims of significant abuse, and many suffer from untreated mental illnesses. The lack of fixed character in children in comparison to adults means that child offenders are more amenable to rehabilitation and educational services and have a greater probability to reform. In Miller v. Louisiana, 2016, the U.S. Supreme Court held that in its 2012 ruling in Miller v. Alabama, affecting mandatory life without parole in 28 states, that it applies retroactively. In addition, California, Delaware, Nebraska, Nevada, North Carolina, and Wyoming followed up with state statutes, removing retroactivity of laws under which juveniles had previously been sentenced to life without parole. I'm certainly not against retroactivity of laws on this subject. However, we have, many of us over more than a decade, worked hard and without a good final outcome on this broad issue. And I thought you need to have opportunities for many different perspectives on the issue. And so that's why Senate Bill 531 is before you. A growing number of states have reformed their respective laws, eliminating life without parole as a sentencing option for all juveniles tried as adults, not only prospectively, but as I said, retroactively. That would be great if that can happen. But if not, this is a fallback position. Currently, the following states and Washington, D.C. have banned life without parole sentences for juveniles: Alaska, Arkansas, California, Colorado, Connecticut, Delaware, District of Columbia, Hawaii, Iowa, Kansas, Kentucky, Massachusetts, Nevada, New Jersey, North Dakota, Oregon, South Dakota, Texas, Utah, Vermont, Virginia, Washington, West Virginia, and Wyoming. So you see, we are behind a lot of folks. Although the U.S. Supreme Court ruled in 2016 that its Miller v. Alabama ruling of 2012 shall be applied retroactively to an estimated 1,200 to 1,500 cases of inmates sentenced mandatorily to life without parole for offenses committed when they were juveniles. We do not ask in this bill for any retroactive relief. This is a modest bill. We want you to have as much in terms of options as possible. The court is not alone in determining that a sentence of life without the possibility of parole is cruel and inhumane punishment for a child. Article 37 of the United Nations Convention on the Rights of the Child also condemns the sentencing option of life without parole for a juvenile offender, as does Pope Francis and the American Bar Association. In light of all of these considerations, I offer you Senate Bill 531 as one more item on the menu. We've got to begin to move this issue and to do what is right, just, and merciful, and what makes sense according to the science of neurobiology. I urge, therefore, your favorable report of Senate Bill 531. Thank you.
Excellent. Thank you, Chair Kelly, and thank you for bringing this before us. I'm looking around the committee for questions. I see Senator Carter has her hand raised. Senator Carter, go ahead.
Yes.
Senator Kelly, I want to thank you for bringing the bill. I know that this has been a long struggle for you and for some of us. You and I had this bill, a version of it when I was in the House, which would require to look back, to have the retroactive part, to have the 300 or so people that we have now serving sentences that were sentenced as juveniles to be dealt with. So I'm going to assume that you've abandoned that part because you're hoping to get something through, because we should have acted by now. We should
absolutely
have by now. My question, if you know, is since Miller versus Alabama, or since 2012, or even since 2016, are we aware of how many such sentences are happening in Maryland still? Or are we just still dealing, we have about 300 inmates that are serving life sentences?
I don't have an up-to-date figure for you at the moment, but you have more than 300 such inmates in our system in Maryland right now today.
Thank you.
Excellent, thank you. All right, Senator Castley, you're up.
Thank you. Senator Kelly, are you saying that there's more than?
Hold on, Senator Castley, hold on. You're muted. Something happened. Go ahead.
Okay.
Yeah, there you go.
Thank you. Thanks, Senator Kelly. I'm just trying to understand what we just said here, because I kind of got lost in that colloquy there, back and forth between you and Senator Carter. Are we saying that there are currently in Maryland facilities 300 or more inmates who were sentenced as juvenile offenses to life without parole?
That's correct.
And they were sentenced for, that number seems very high from what the previous years. I think we calculated this, basically the sentence is imposed once every 2 years on average. And that would be too many. What
a lot of them have gotten quite old. We have them in hospice now. We have them on walkers. We have them so neutered in terms of their physical condition that they couldn't harm anybody, even if they were not reformed.
Right. So, and these were, okay, we'll try to get those. And then I guess the question comes up every year is that your position is you could not conceive of a crime by a juvenile sufficiently heinous that it would ever justify life without parole.
I am saying that the science of neurobiology, and I actually attended conferences within the last 6 or 7 years, several times, put on by many organizations that have great veracity on this issue. I've attended some with Sam Abed and some with Judge Barbera, where we really spend a lot of time on just what the science shows today.
That's on the rehabilitation side. We're talking about.
Well, no, I'm just saying about the inability of young people to have the impulse control and the ability to pull back, and especially considering the conditions in which, and so in terms of how they got sentenced in the first place. Some,
of course, most young people do have
very heinous
controls. We're
crime.
talking about a minority of people who, for whatever reason, don't exercise the impulse controls. Most overwhelmingly, youth don't go out and kill people in cold blood. But
well, what the science is showing is that more.
I understand that, but I mean, my question is really simple one, which is, can you conceive? Could a juvenile ever commit an offense that was just so repugnant that the concept of that individual someday walking down the street and being happy while encountering his victims, his many victims, surviving relatives, that was just, we couldn't tolerate that person would commit a crime that was so heinous, and then someday the small child who witnessed his mother's gruesome demise would then walk around and see, oh, well, there's the guy. Yeah, he's now, it's this local car dealership. Yeah, he's the guy that blah, 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 blah to my mother. It was, destroyed my life.
You asked a very good question, Senator, and let me try to answer it in two ways.
Mm-hmm.
One is that some people won't end up being reformed. And nobody is saying what should happen to them years later. But the sentence initially, since you don't know who can be rehabilitated, and when they are only a child, considering what we know about the neurobiology now, and about sometimes their own personal history.
Okay, so I guess, it sounds like the answer to my question is no, that a juvenile could never, a 17-year-old could never, in your view, commit an offense that was just so repugnant, so repulsive, so damaging to society that we could ever conceive of giving them life without parole.
The truth is, we don't know in any case at the time of the initial sentencing. So that's why you don't want to put a block on that's forever, and not give the courts and the criminal justice system and the parole commission the ability to.
But you will be taking that
happens during that interim.
This bill would tell them. Your bill would tell the sentencing judge and the juries that they could never, that there is no crime sufficiently repugnant that a 17-year-old would ever get life without parole. That's what this bill would say, right?
No, this bill is saying going forward, you don't do that up front when it's forever, and not know that there are possibilities of human rehabilitation, that there are possibilities of a person doing what's right. If I can just answer in one way, I'm thinking of a particular case of somebody who got life. Well, he even got it with parole, though he hadn't gotten it. I'm thinking of a young man that I knew when he was a toddler in Baltimore City. Father, a medical doctor, mom, a school social worker. He was 7 years old. He was a bright and really nice.
But can you're not really.
Let me just finish.
These are nice discussions, but I guess, Mr. Chairman, I'm done because clearly she's not going to respond to my question.
Well, I'm trying
to answer. So thank you, because this is just not responsive. We're just going to go on with another 10 minutes. So thank you very much. I appreciate it. Have a nice day.
You, a member of the committee. You got to let the witness respond. Chair Kelly, go ahead and respond.
What happened is that at 7 years old, somebody broke into the house in the middle of the night. They shot the dog in front of the child, tied up his father, and raped his mother, all in front of this 7-year-old. He was not, from then until the day that he was convicted of a crime, ever the same human being. He was so traumatized by what had happened, and he was very young, only 7. All I'm saying is that now that he has been in for decades, he has a college degree. He's done a lot of good works. He has worked with prison ministries. We can't decide up front given the circumstances at the time of the original trial and sentencing, that are who can be rehabilitated and who cannot. And when they're a child and they've got neurobiology against them, as well as in many cases, childhood trauma that they have experienced, you don't know. You don't want to take away the possibility of any human being who can be rehabilitated and could safely enter society. Not at that time.
Excellent.
If they never show rehabilitation or that they're better, there's nothing that stops a parole commission for keeping them in. But we ought not to a child make that decision, not knowing so much more about both science and social science, which impacts their individual cases, and to do it up front.
Excellent. Thank you, Chair Kelly. I see another question from the committee member, Senator Heddleman. You're up.
Thank you very much, Mr. Chairman. Madam Chairman, is there anything in this bill that says that a person should not be held accountable for their crime? The crime that
No,
they
absolutely not. When they at the time of sentencing, you want to make sure that in fact that does happen.
Thank you.
Sure.
Excellent. Okay, looking around the room for additional questions, seeing none. Thank you, Chair Kelly. And with that,
thank you.
Thank you. And with that, that'll conclude the hearing for Senate Bill 531. We'll now move on to Senator Casserly, Senate Bill 495. If we can get the senator back on camera here, we'll rock and roll. All right, Sandy, if you could give a call up to his office and I'll text him, but he is this is the last bill of our hearings for the day. So we'll sit tight for a minute or two here.
His staff is working on getting him back.
Excellent, thank you. Excellent.
Thank you, Chair. Sorry, had to run to the restroom.
No, I hear you. So I don't, Mr. Schellenberger is, I think, testifying in the House.
That's all right. I'll roll with it. That's okay. It's not too complicated. It's a pretty simple bill. And all it says is that, so this deals with reckless driving and negligent driving. If you get a ticket for reckless driving or negligent driving that results in the death of another driver, that you must appear and pay the fine. You must appear in court. It's not a prepay. So it's a pretty limited application. Fortunately, it's not, every day that someone gets ticketed for causing the death of another person, either through reckless or negligent conduct. But in those instances it does, it's a must appear, and it really just has to do with it's important for the other family members to see some level of remorse, and that their loved one's death was not result simply in somebody dropping a check in the mail and moving on with their life. They must come before the judge and the victim's family potentially, and in a courtroom. That's it.
All right, excellent. Thank you, Senator Casserly. Senator Carter has a question. Senator Carter, you're up.
Thanks, Senator Casserly. I feel like, thanks, Mr. Chairman, I mean, Senator Casserly. I feel like I've seen this bill for a long time. Is that correct? Has this bill been around in the past, or maybe sponsored by you or other people?
I've not had this bill before. I can't tell you whether, I know we had a similar bill, not quite exactly like this before our committee last year is my recollection. But I don't know that we had this exact bill. I just picked it up this year.
Were you basing it off of any specific instances that occurred in your district?
Yeah, there was, it was one out of Baltimore County. And I'm sorry, that's why you don't get the story, because we went without Mr. Schellenberger being here. So I'm sorry. I don't have the story. He would be able to get the personal story. So.
Senator Carter?
Yes.
I think you're thinking of the vulnerable road user, which has a similar idea here. And if I put the two bills together, I actually think that Senator Cassidy's bill might be kind of essentially a lesser included, but I'm happy to work with Senator Cassidy if there's kind of merger and Cassidy, I'm happy to.
Yeah, no, and I like your bill, so I don't have any problem looking at a merger of the two.
Thank you.
Okay.
Excellent. There you go. All right. And with that, I don't see Mr. Schellenberger here in the waiting room. So with that, that'll conclude.
So you don't get the story. Sorry.
Here you go. Got it.
Or maybe that's good. We don't have a less gory story for JPR. It's not like we need any more of them.
Save us the gore. There you go.
Yeah.
All right. Well, with that, that'll conclude the hearing for Senate Bill 495 and our hearings for the day. So what we'll do, Senator Carter's doing a little dance. Here we go. So let's do this. If we reconvene at 3:30, we'll be out of here by 5:30. Does that work? Does that work? Thumbs up. Is that cool with everybody? So Senator Bailey, go ahead. And then Senator Sidnor. We're not meeting in person, but we're capping at 2 hours. So
that was my question.
Yeah, that was up.
Yeah, it's
Me
remote,
too.
but I'm not sure we can do this for more than 2 hours at a time. So that sounds good with everyone. All right, you want to do 3, Senator Castle? You want to push to 3? Sorry, hold on. Hold on. Can you unmute yourself one more time? There you go.
Starting at 3:30. I just want to confirm.
Correct. 3:30. We're out of here by 5:30.
Okay, I'm good. Thank you.
Okay, great. If we go longer, then dinner's on me. There you go.
And,
All right.
and I just want to remind everybody, this is the same link that you're going to use. I'm just going to put up a sign that says that we are taking a break. So this is the same link that you'll use, Zoom link, to get back into the meeting.
Excellent. All right. See you all soon.
So it sounds like Senator Smith is in bill hearing and finance right now. He said that he'd be in just a minute.
right. Good afternoon, everyone. My apologies for the delay. I was testifying on a bill in finance, so my apologies for a quick delay. I promise we'll still get in. We'll still get out of here before 5:30. If folks are here and have the ability to come back on with their video stream, that would be great, so I know that people are actually here, and then we'll get started. So, hey, good to see you all. All right, Jamie, I guess I'll run through. So the only bill on our agenda for this afternoon is the independent investigations. And again, you may remember from this fall that I had put forth an initial proposal that housed this responsibility in the Office of State Prosecutor. Based on some of the conversations I had in the interim, decided to move that responsibility to the Office of the Attorney General. Did a review of several other states that have kind of moved forward under this model: Wisconsin, Connecticut, Utah, New York, Georgia, New Jersey, have all recently implemented some form of independent investigation that's housed within the purview of the Attorney General, or they've established an independent body to do these independent investigations. So as you may remember from the hearing, what this bill would essentially do is for officer-induced deaths that were with a firearm or a violent officer-induced death, that would fall under the responsibility for the Office of the Attorney General. Hold on, see, Senator Cassidy's got a note here. Sandy, if we could help Senator Cassidy with his video, that'd be great. So essentially would house that responsibility. They would have the responsibility to conduct those investigations. There you go, got you. Conduct those investigations, furnish a file, and furnish that file and the results of that investigation to the state prosecutor of the jurisdiction in which the incident occurred. That state prosecutor would then have essentially 45 days to decide to prosecute or decline, at which point the Attorney General's office could move forward or just move along with the state prosecutor's action, do nothing. That report and that investigative file would also include a recommendation for prosecution. And so that's essentially and Jamie, if I forgot something, remind me, but that's essentially those are the broad strokes. The idea came from ensuring that there is some level of transparency, independence, and accountability with this investigatory process. Now, as you may remember also from the hearing, I think 2 jurisdictions have engaged in an MOU. It's Montgomery County and Howard County, by which this type of instance would be investigated by the opposite jurisdiction. That has worked with varying degrees of success. So what this would do is kind of pull us back. You'd have one entity responsible for these investigations and recommendations for prosecutions in these limited instances, and that responsibility would be housed under the Office of Attorney General. I'll say that there was some discussion over the fiscal note, how much it would cost, and we talked about the numbers of actual numbers of death that fell under this. So I think that this is, another benefit for this schematic is that it's fiscally possible and more lean than the other options that we've pursued in the past, or that I've put forward in the past. So with that, Jamie, I'll turn it over to you. You take it away, and you can kind of do a rundown, and then we can move forward after that.
Thank you, Mr. Chairman. So I think you hit on the points that I was going to raise about the bill, but just to recap, the bill requires that the Attorney General investigate all alleged or potential incidents involving the death of a person caused by a police officer. A law enforcement agency would be required under the bill to notify OAG of any potential incident like this. As soon as the law enforcement agency became aware of the incident, and the bill requires that the Office of the Attorney General prosecute the police officer, in the circumstance that the local state's attorney's office either declines to prosecute or doesn't respond within the 45-day window given under the bill.
So with that, we can switch over for questions, comments, concerns. Senator Carter.
Thank you, Chairman Smith. You know, we've had a lot of dialogue about this concept over many months, and I just wanted to know from you, you had ultimately decided on the Attorney General's office. I believe the bill has an option for the state's attorneys, which they had wanted, but you selected that over the idea of a completely independent entity or the state prosecutor. And so I just wanted to hear, you know, your reasoning for why this proposal is the best of the many that we've discussed. And I truly just want to know. It's not, no, I have no preconceived beliefs about it.
No, I hear you. So a couple things. One, we had some fiscal concerns. You had some concerns over accountability. So one thing that we heard in the hearing in the summer was that if you put it with the Office of State Prosecutor, then that person is appointed to a 6-year term by the governor and therefore insulated from kind of political accountability. And so I took that to heart. Also, if we were to go that route, you'd have to essentially double that office with resources and construct some things. I think I actually thought it was an elegant proposal, and I liked it a lot. And you know, if all things being equal, if we had the resources, I think that you know, that would be, you know, it would be a great option. But given the fiscal concerns and given the concerns of some members, and especially in the Black Caucus that I spoke to about the political accountability, you know, we decided to go with the Office of the Attorney General just because it was a more kind of a lean solution that it seemed to be very just more streamlined and simple. And so, you know, those are the major elements of, you know, went into my decision making to put this proposal forward this time around. So you've got the political accountability that answer that question. You've got, I think, the fiscal note and the fiscal concerns are, I think, addressed, and you know, that's essentially it. I think I said Senator Bailey, and then sorry, Senator Carter. Go ahead. Are you good? Hold on, one thing. There you go.
Thank you. And also why you had narrowed this down to drill this bill down to just dealing with death over other instances as well. And what do you anticipate would be the actual requirement for this division of the Attorney General's office when it's looking at solely that one category, just death and not serious? Is it death or just death, or is it death and serious bodily injury? Just death. Just death.
We limited it because, again, the fiscal concerns that were raised. And I think, you know, you had similar dialogue when New York did this. So New York did this by statute. The governor did that in 2015 by statute, and the legislature went ahead and codified it last year in 2020. And so it's an interesting thing that happened in their hearings and in their dialogue. The Attorney General was happy to do it, but said, look, you've got to give us the resources. And so the resources were concerned. Also, you could start in these limited instances, see how it goes, and then build if you need to and if you can. So I think that, you know, doing it this way, it addresses the fiscal concerns and gives us an opportunity to see how this works. I mean, I think it's going to work well, but it gives us an opportunity to do that. So the caseload, and that we had this kind of discussion during the hearing, you're looking at essentially 18. So in calendar year 2019, there were a total of 31 civilian deaths involving a law enforcement officer in Maryland. Of the 31, the medical examiner's office said that 18 were as homicide by law enforcement officer, 5 as suicide, and 7 as accidental, and 1 from overdose. So, and they averaged it over the course of 3 or 4 years. And so they suspect that you'd have something around 18 cases, 13 to 18 cases a year. So not, you know, not a significant caseload.
Thank you.
Senator Bailey. Like a hearing all over again.
Okay, thank you very much, Mr. Chairman. So The police officers that work for the Attorney General's office that will be investigating this incident, who do they work for?
So the way this would work is that you'd have state police do this, and Jamie, you know, we've done this research. So you'd have, if you have, let's say something happens in St. Mary's, right? You'd have the state police do it. So the local jurisdictions would not be involved in investigating. It'd be state police. And if the state police were involved in something, then it'd be opposite.
So that was going to be, right, that was going to be my next question was, I've actually, had incidents where, there was some shootings, and then state police came in, did the investigation start to finish, as an outside agency. And it actually, it was completely clean because it was a different agency that did the investigation. But having worked with the Attorney General's office and criminal prosecution, that's what I was going to say. They were all state troopers, so that if the state police were involved in a shooting, then it wouldn't make sense to have the same members of that agency to investigate them. What does this do to the? I know in St. Mary's County we have had some actual shootings involving law enforcement, and the state's attorney has his own investigators that work for them. They do the investigation. They then present the case directly to the grand jury for indictment. And of course, the grand jury is made up of all civilians. So they have an immediate civilian review board that evaluates what the police officers did to determine whether there was any criminal wrongdoing by the police. And as we all know, I mean, you can indict a ham sandwich if you want to. So that was a question that what is going to happen in some of our rural counties where we do use the grand jury very effectively.
So Jamie, correct me if I'm wrong, but I think for this limited slice of case, which I actually don't know how many of these events have actually happened in St. Mary's. St. Mary's, looking at the fiscal note, was not, I don't think, consulted for the composition of it. But for this limited slice of case, it again would fall under the purview of the OAG, and that would be housed there. That responsibility would then be relegated to the Office of the Attorney General.
So, and the only reason I raised that question is a lot of what we're talking about here is we want some type of, the people that live in an area to be engaged and involved. And quite frankly, the constituents have elected the state's attorney. The state's attorney is the chief law enforcement officer in that county, right? He or she are the ones, and their office are the ones that decide this. That is the role that they have always played. So that was, and they utilizing the grand jury that brought the civilians into the process, because this is dealing just with criminal issues. So that's where I was. I just wanted to understand that we were going to first off, obviously I'm not opposed to using investigators from another agency. Quite frankly, because when you've been through something as traumatic as somebody that you worked with was involved in one of these, you don't want the public to see if there was any bias one way or the other, right? You want it completely clean. I think everybody would understand that. But when it comes to the prosecution, you would want people in that community involved in the grand jury. You would want that state's attorney involved, where the coming in with the Attorney General. And quite frankly, it's been my experience that unless we do a lot with the Attorney General's office, we're going to have to give them a lot of resources. To trying to get them down to St. Mary's County is a rather cumbersome task to get them to take a case to come down there. They're not as willing to do that, clearly, in my experience, as they might be in some of the metro areas.
No, I hear you. I mean, look, just looking at the resources and the fiscal note in our conversation, that they're fully capable of doing it if we give them the resources that are mentioned here in the fiscal note. But Just another point to note is that, again, after the investigation is complete, which the Office of the Attorney General would work in concert with the state police, that your local state's attorney still has, 45 days to say, look, I'm taking this, and exercise their process locally. So that opportunity is not foreclosed. So it's only if, so they have the first kind of right at that point after the investigation. So this model actually is in operation already with the Office of State Prosecutor. So the Office of State Prosecutor will investigate public corruption, do the investigation, and then turn that file over to the state prosecutor and say, look, what are you gonna do? Recommendation for prosecution, whatever, and that local state's attorney still has the control to go forward. So, 45-day window, but that control is still there if that state's attorney wants to exercise it.
Well, and the only thing I would say is my experience with the Office of the State Prosecutor, they are extremely limited also in their ability to do things in rural areas, right? They're much more apt to work in their backyard than they are to come down and visit us in more rural areas.
It's always a matter of resource allocation. They've got a lean staff of, I think, 6 or 7 people. So
thank you.
That's a fair point. Thank you. Vice Chair Walter.
Thank you, Mr. Chairman. So my question is, I think, actually the opposite of Senator Bailey's. So if there's a state's attorney, I understand that most of the testimony here has been that the state's attorneys want to retain control. But if there's a state's attorney who doesn't want to affirmatively decline to prosecute, for lack of a better term, nor wait the 45 days, can they just go to the Attorney General's office and say, we hand it over to you?
I think the bill leaves that door open. So it's not in the declination stack, so to speak. Then the attorney, and Jamie, correct me if I'm wrong, but I think that option is still open for the Attorney General to move forward. We played around with language about just, obviously if you didn't give this 45-day window, obviously you're kind of master of your own domain in that you control the investigation and then the prosecution all the way through, which I suspect most people would say that's ideal, but it doesn't necessarily lend itself to that era of kind of separation and independence in investigation. But Jamie, the door is open as I read it.
So, right, looking at page 3, just starting at line 5, says that within 45 days of receiving the report under the subsection, the state's attorney shall notify the Attorney General whether the state's attorney intends to prosecute. Now, maybe to that point about whether the door is clearly open, in the next subparagraph, it does use the word decline to prosecute or fail to notify the Attorney General. So I guess getting to that point, it could be cleared up or clarified a little bit more in the language to get to that point, but it doesn't seem from the language that it would be foreclosed. If declining to prosecute was interpreted as requesting that the Office of the Attorney General be the prosecuting agency, I think that's where that would fit in.
All right. Well, I'll defer to the sponsor of the bill. I think a clarification could be useful, but I can see where your interpretation is coming from, Jamie.
Noted. We'll definitely work on that. So I saw Senator Lee first, and then Senator Castley.
Yeah, thank you, Mr. Chairman. I just got a quick question. You might have already answered this because I got on a little late. Does this preclude a county state's attorney office from going ahead and doing its own investigation where it involves death? Can they do their own? Or do they have to wait for the Attorney General to issue its recommendation?
So it's the Attorney General you have to notify immediately. The local jurisdiction has to notify the Attorney General's office immediately, or as soon as they become aware. And then the Attorney General shall investigate all the alleged potential incidents involving the death of a person caused by a police officer. And then, so this puts the Attorney General in control, their office in control of that investigation. And then within 15 days of completing that investigation, they're going to go ahead and give it to the state's attorney of the jurisdiction in which the incident occurred. and then that person would have 45 days to either prosecute or not. So the investigation is left to the Attorney General. I think that pretty clearly seals off. I mean, I'm not, Jamie, you answer the question, but the way I'm reading it is that means that the state's attorney couldn't, I mean, I suspect they could do it in parallel, but they could do their own parallel investigation. It doesn't preclude that, but the Attorney General has to be involved in it. I'll put it that way. Has to be involved in their own independent investigation.
Right.
Yeah.
So I don't, the way that the bill is written provides for, this is page 2, lines 16 through 18, that the Attorney General shall investigate all alleged potential incidents involving death of a person caused by a police officer. It doesn't in the bill foreclose the possibility of a concurrent investigation. I'm trying to remember off the top of my head if there might have been some testimony on the practicality of that, and whether there was any testimony or feedback submitted on whether it would be possible to, just from a practical perspective, to run concurrent investigations.
It's a very good question though, Senator Lee. Definitely get the swift resolution on that. Senator Castley.
Thank you. So I guess picking up where Senator Lee just left off, I have sort of a similar question. I would think that we wanted the bill to be clear that until, well, preliminary was, did I understand that, I don't see state police mentioned in here, but I understood you're saying that the Attorney General would use the state police, but doesn't that need to be clear in here? What just seems to me that has to be explained, that unless that's already in another law, that Attorney General investigation is automatically through state police. Wouldn't we need to mention that in here?
So I'm not aware that it's in any other part of the code, frankly, but I think you maybe want to be more prescriptive. So the way it's drafted gives the Office of the Attorney General latitude to do this, and they obviously can deputize the state police to do this. They'd have to have an MOU to do the locals. Jamie, correct me if I'm wrong. I think they'd have to have an MOU if they're going to use local police to investigate the opposite way around. But they can do the state police, and that's just in the conversations the way that it was. That's the way that it was. This would practically work. So you're right. It's not. We're not as prescriptive in the bill. We kind of leave that responsibility to the Attorney General's office to kind of figure out.
And that leads to my next question, because we don't really. I realize investigate. Well, maybe it needs to be defined here, but it seems to me that it leaves open the several possibilities. And I'm not foreclosing any of them, but
yeah.
Investigate can say the local police offices conducting an investigation, and the Attorney General has the authority to step in and say, I'm joint here and I can look at your investigation, or if you're not going to do it, I can bring in my own resources. But it just seemed, at crime scenes, we would not want any suggestion that, hey, that was the Attorney General's responsibility, not mine. Crime scene, the first 50 cops on the scene are going to be from the local jurisdiction, because there was a shooting and the call went out, and suddenly you've got 50 cops there securing the crime scene, conducting initial investigations, all the photographs, all the initial witness interviews. The state police just aren't going to be able to provide that level of necessary instant response to a police-involved shooting. So we wouldn't want in any way suggest that the local jurisdiction is absolved or excused from the investigation. And that's just, I just concerned the way I read this. I wouldn't want to, that local department seems to me would still be responsible, and local state attorneys should still be responsible as they normally would for coming out, and that we're really looking at almost a concurrent, then the Attorney General guy shows up at some point, and then the state police come rolling in. That obviously we want them to have unfettered access, but and they could also conduct their own independent investigation. But I think this is a practical matter. I think we would not want to in any way suggest that local jurisdiction was not responsible for those first few critical hours of conducting a high quality criminal investigation until the state could marshal the resources. I know, I mean, in my county, at any one time, there's like 3 police officers on duty in my county at one time. And I think a lot of other counties are probably in the same way. And in other counties, it's a larger force, but there's not many of them there to do anything. My first point. My second one was that I guess looking on page 2, line 25, the Attorney General finds that a crime, I guess it really should say by law enforcement, has occurred. That's all he cares. If this is just another crime, it wouldn't be. These are all law enforcement crimes that the state, that the Attorney General is looking at. And then I think on page 3, line 7, you would not want to unintentionally deprive a state's attorney of jurisdiction. So I think we'd want to say that deadline, that 45-day deadline, could be extended by mutual agreement of the Attorney General and the state's attorney if they're waiting, for example, on some kind of ballistics test or some high-speed test, and then the 45 days goes by, and then the defendant would argue that, hey, the local state's attorney just lost jurisdiction here because they didn't notify the Attorney General within 45 days. So that they would be able to, I think the real intent here is that the Attorney General could say, hey, you forfeited this, you've been screwing around with us, 45 days is up, I'm in, right? That's the real intent here, but we wouldn't want to leave somebody the possibility. So just sort of initial reactions to this. And I think, Mr. Chairman, I think you did it. The one aspect of this bill I like is that, by restricting it, as you pointed, to fatalities, it would be a good way to start and take a look and really address the most serious ones, right? And not every little infraction which would be inappropriate. So I think that's a positive step here. So that's all I got. Thank you.
No, I appreciate this. There's excellent feedback. So I wrote all that down, and we've got and for Senator Bailey too. I'm meeting with state police again on this bill just to ferry out some of the details, see how things work. So I'm meeting with them later on this afternoon. I think after 5:30. So I'll have more feedback for everyone when we come back, whenever that is. Senator Bailey.
Thank you, Mr. Chairman. Just a couple more points, and maybe Jamie or you know this. Does this bill take any authority away from the elected state's attorney in a county? It was always my understanding, and I might be wrong, that the state's attorney had the ultimate authority, because my experience with dealing with the Attorney General's office from around the state is anytime that we went to them for an investigation, before they could go into a county and actually prosecute a case, they had to go to a meeting with the state's attorney, and the state's attorney had to agree and give them permission to enter that county and to actually prosecute the case. What if the state's attorney wouldn't agree to it and the prosecution, and he said, no, right? This is not going that way. I'm the elected state's attorney, and I'm going to deal with this in my county. The people elected me, and this is what I'm doing. And I didn't know legally how that worked out.
So in terms of, the investigation question that Senator Lee mentioned, I think that's why that was intriguing. It doesn't deprive them that, it doesn't seem to deprive them the ability to do their investigation, although that would pose some interesting logistics between if you had 2 investigations going on in parallel. So that's interesting, and we've definitely figured that one out. But it says that, look, if you have you got that 45-day letter, just kind of the same model as the Office of State Prosecutor. And so you've got that time to make that decision point. That's the decision point. And then if you decline, the language says, if let's say the recommendation is that the Attorney General says, look, you shall, we're recommending prosecution. And then the state attorney says, no, we're not going to do it. The way that it's drafted, it says the Attorney General. So it says to prosecute, if the state's attorney declines to prosecute the case or fails to notify the Attorney General as required of this subparagraph, the Attorney General shall prosecute the police officer. So if that recommendation is made from the investigation and then the state's attorney doesn't do it, then it's a shall. So I don't know if it deprives them of any of their responsibility. I mean, I don't think it does that. I mean, you know, you've got the ability to decline and move forward. I mean, Jamie, if you have input on there, you can go forward.
Sure, and there is constitutional law on the issue, and unfortunately, as I was trying to look for it as you were asking the question, Senator, but and I can get back to you on the specifics. But as far as the requirements of the bill and whether it would take away or interfere with take away the state's attorney's constitutional duty to prosecute crimes or have the discretion to. The way that the bill is drafted does provide for giving the state's attorney that first right to prosecute the case, and then if they declined or didn't respond, it would that authority would go to the Attorney General.
So, so that is, if you could provide some clarification for that, and I might be, over my head on this, but from my understanding, the state's attorney was always the one that had the ultimate decision. And if the state's attorney said no, this is my prosecution, this is the way I'm going to do it, the Attorney General's office couldn't trump him. And I just wanted to know that to find out both constitutionally and in the letter of this, if this is taking away any type of authority that the elected state's attorney has at this time.
So I was looking for it. So your answer actually there's some in my testimony from the first time I put this general concept forward over the summer, and Jamie again, just have chime in. So as long it gave.
Unfortunately, I wasn't here in the summer.
Yeah, no, I hear you. Yeah, I'll make sure you get it. But the analysis is that you just, as long as you don't abrogate or basically take away all responsibility of the office of the state attorney, then the legislature can, do this. So for the investigations and for certain other roles and responsibilities, that is constitutional and legal. And I don't have the case site, Jamie, if you do. But it's in my materials from the summer, and I was looking for them right now, but I'll be able to give you the case site for it because that question did come up over the summer. In fact, that was a major point of contention in the summertime, and a line of argument that you did not hear repeated this time around because I think we successfully addressed it the first time.
Okay, thank you.
Jamie, do you have that case site? Do you remember that? You know what I'm talking about, right? You remember what I'm talking about?
I do, Senator. I was looking for it in my inbox, but if I locate it before the end of the meeting, I'll bring it up.
Or Luke, if you can find it. I don't know. All right, if you're listening somewhere. Okay, Senator Hettleman.
Thank you, Mr. Chairman. I guess I have some concerns along the same line as Senator Lee, but my other question is, do we have anywhere else where we are asking one entity to do the investigation and another one to do the prosecution? I guess I have a hard time wrapping my brain around a state's attorney not wanting to do their own investigation. And then sort of, taking a package from the Attorney General's materials or, investigation, and then kind of running with the prosecution. How do you envision that handoff?
Happens all the time with the Office of State Prosecutor, same exact model.
Except that don't they do their own investigation?
The Office of State Prosecutor can take it and do their own investigation. They do the investigation, and then they furnish the results of that investigation. It's the same model. I mean, I took it exactly from that model.
But aren't they doing the prosecution? Are they handing it off to a state's attorney?
It's a 45-day letter as well for the state's attorney. Same exact model.
Okay, and it works. I mean, and that's what happens. The Office of the State Prosecutor doesn't do their own prosecution. They're handing it to a local state's attorney. They
can, but they do. They offer that file. Jamie, correct me if I'm wrong. I mean, I think that happens every year.
But does it happen then that the state's attorney's office does the prosecution, or most of the time is the state prosecutor investigating and then doing their own prosecution? That's what I'm trying to figure out.
So I don't have those. I don't have the exact breakdown or numbers. I'm sure I can get it for you though. Jamie, do you know? I don't know.
No, I don't, Senator. I'd have to reach out to the state prosecutor's office, but I guess just information to add to the discussion. Right, the language isn't a one-for-one match with the statute authorizing or that contemplates the 45-day letter with the state prosecutor, but it is modeled off of that language, or it's very similar.
Okay, I can check with them too. And my other question is,
just to answer the other question too. I mean, just as you're probably well familiar that, you know, with Montgomery County and Howard County, they've entered an MOU, and so one entity does the investigation, the other entity does the prosecution, and that entity does the investigation and prosecution and for that opposite jurisdiction. So it's not exactly on line with your question, but there is ceding of that responsibility outside of the jurisdiction of where that event occurred.
right, okay. And one follow up on a different topic is I sort of feel like the one big absent entity here is the Office of the Attorney General. And I just wondered if you could comment on how they feel about taking up this responsibility. Let's put the resources aside for a second.
So their testimony is silent on the matter, but I'm sure we could talk to you. I can talk to you offline.
Okay.
Oh, Senator Kessley.
Yeah, I'd just like to pick up where Senator Hedelman left off, because I think she raises a really valid concern that when the Office of the State Prosecutor, I mean, normally they would conduct an investigation of an official taking a bribe or something like that, which is a pretty straightforward. They collect the wiretaps and then they package it up and give it to the local state's attorney to prosecute it once they have the crime done. But that doesn't at all compare to a major crime scene investigation of a killing, which is now obviously now it's a murder scene because you're prosecuting somebody for it, with tons and tons of witnesses and physical evidence and forensics and all this stuff. I mean, there is the local prosecutor would necessarily have, working with the local law enforcement, would necessarily have conducted an extensive investigation, and I would envision under this that the state police would have been involved as well and in and out of the picture and perhaps supplementing, but I just don't think it compares any way to the Office of State Prosecutor doing their wholly independent sting operation on a politician who took a bribe. They tie that up in a little ribbon, hand to the local prosecutor and say, here's the tapes of the wiretap, here's the bag money we took, go prosecute them. I think we really do need, if we're going to go with this, to really look very carefully when we talk with state police and folks and the local jurisdictions, local prosecutors, to come up with a mechanism that actually works, that allows the locals to move forward with their investigations, albeit under the auspices or in cooperation with the state officials. But you've got to have a local investigation going full bore here, and eventually in the end, maybe the locals pass over their investigative files to the Attorney General. I think it needs a lot of work to make something like that work. Did you just consider the possibility of just bringing in that maybe you wouldn't just have a prosecutor assigned, like treated as a conflict of interest, which happens every day, where the prosecutor says, well, that's my, whatever, I know this person, they're a good friend, and you reach to the next county over and say, you prosecute this case. I mean, rather than taking this all the way to the Attorney General, just maybe the Attorney General would be the one who would say, hey, I'm not comfortable with this case, and I want to add you, I want you to bring in somebody outside to prosecute it. It doesn't have to be the Attorney General's office, but certainly a neutral, a third-party prosecutor who's just because they see a potential conflict. Just a thought. Thanks.
No, I hear you. And I wrote for your first part of the comments, I wrote that down from before. I mean, I think those are very good points, and definitely lines of inquiry that I'll pursue, tonight and tomorrow morning. But for the others, for your suggestion, no, I hadn't pondered that. I don't think that meets the mail for like the type of independence that, you're looking for. What you've mentioned this before, of like a, maybe a model in which the Attorney General would come in and say, they have the ability to kind of look under the hood okay, cool, the conflicts checks have been run, everything's good, like we're all copacetic here, almost like the federal model. And so, you know, I think that's certainly something I've been kicking around as well. Yeah.
And there's also we have the models of the special prosecutor model on the state side, where a judge comes in, you know, and says, we're going to appoint this person from wherever to be the local prosecutor. And then you really take it out of all the political, because you just have a judge reviews the case and says, well, I'm going to appoint Fred Smith, you know, out of Charles County to be the prosecutor of this, and come in and review it and do it anew. And then it's not totally depoliticize it. You know, you get a judge who's got a 15-year term left, and they're the ones that say, I'm picking the prosecutor for this, or approving it, or a panel of judges. Anyway, just
no, that's another
politicizing it. There's some other methods. So,
got it. It's very good feedback. Very, very good. Senator West. Sorry, good. There you go.
Mr. Chair, now I followed you in the Finance Committee with 2 bills. So I've just arrived, and if my question's been asked before, warn me off. My question is there any thought being given to inverting the scheme here, requiring the state's attorney to do the investigation and make a decision whether or not to prosecute? And if he decides not to, or she decides not to prosecute, then the Attorney General would get the investigatory file and could take a look at it and make an independent decision about whether the Attorney General wants to prosecute. Since the state's attorney is not going to do it, that the Attorney General could decide to do it. That way you'd leave prime responsibility in the hands of the county elected official, whose job it is to review and prosecute these cases. And only in the case that the state's attorney would make the decision not to prosecute, would the Attorney General take a look at it.
So you just came in on the end of that tail end of that conversation. We talked about this. Not in this conversation today, but before I've had that with Senator Castley, almost like a federal model in which you'd have, the Attorney General come in and say, take a look, see, be able to look under the hood and take a hold. So that's, I think that it's a step away from the type of independence that you're looking to exercise in terms, especially for investigations up front, but it's definitely a step in the right direction, right? It's a step back from where this is, but certainly a step in the right direction. So I appreciate that. I'm going to run the traps. And like I said, I was going to do some research tonight and then tomorrow morning. And so next time we come back and talk about it, I'll have the answer, I can talk around some of these different models. And I'm meeting, like I said, I'll be talking to some folks tonight, and state police, and I'll be reaching out to the Attorney General's office, some other folks too, state's attorneys. I talked to a couple of them this week about this.
I haven't discussed that idea with Scott Schellenberger.
No, we're spitballing here.
Attorney. So,
yeah.
But I would think before we went in that direction, we might want to check with him and see what he thinks of it. He may say that it's a terrible idea. But
yeah. I suspect he's texting, Senator Hedelman, Senator Sidnor, and you. If not, he probably will be. But I'm sure he'll burn the lines up. Excellent. All right. Well, a lot to think about. Definitely some good feedback, and I've got a lot of work to do. So I appreciate the committee for the feedback. Don't know where the votes are, but I appreciate that. So if we've exhausted this subject, I don't want to tack on anything else today, because we've been working pretty hard this week and last week. I'll just say that when we come back tomorrow, I think we've got a couple of amendments to entertain. We'll start off with, I think Senator Jackson may have one more amendment for the Law Enforcement Officers Bill of Rights, and then maybe I know Senator Bailey has a couple of amendments that he'd like to consider. So I'll give Senator Bailey, Senator Jackson the floor first. When we come back, we'll have an opportunity to have a full discussion on that, and then I think as we've spoken of it, we'll turn back to the MPIA discussion that we had, and then we'll end up with this if we have time on Wednesday. Also coming down the pipeline, just the Baltimore City Police Department. You heard that we had that hearing last week, returning local control. I think that bill and the amendments from the sponsor are ready and have been approved and vetted by the delegation. So I'd like to entertain that. I don't think that'll take a whole lot of time. Okay, I see some shaking the head. No, it's not done yet. So when it's done, well, I don't think it'll take a lot of time in committee, but I definitely want to give all deference to the Baltimore City senators on that one. So I will see you all tomorrow morning. Sandy, when are we scheduled to come back?
So we have bill hearings tomorrow after the floor session. We've got 11 bills. The hearings may be a little lengthy, and then we'll convene in person after that. And then Thursday, we were talking about starting at 8 a.m. and going until 10 and then taking a break and then coming back.
Okay, how about, can we push that back? So 10 is floor?
No, but there's a meeting at 10, I believe.
Can we do 9? I mean, the 8 a.m. is rough. I mean, let's do 9 o'clock and let's do 9 to 10, and then, folks can roll off to their meetings. Since, I mean, it's all on Zoom, so you just click a link. So it's not like you're traveling anywhere, walking to the link. Is that okay with staff? Is that possible?
That's fine with me. That's completely up to you, but they do have to be in person for voting. So
let's do this. Let's do 9 o'clock. 9 o'clock works better than 8.
Sounds good.
That's a voting session at 9 o'clock?
Yes, on Thursday.
But tomorrow is what?
Tomorrow is when we're done the hearings.
Yeah, so afterwards.
Yes,
Lee, go ahead.
correct.
Yeah, I'm sorry. I walked out of the room because I had to go take care of. So for tomorrow, are we doing voting or is it just hearing? And are we meeting at 9 o'clock in the morning?
So tomorrow we're going to vote after hearings, and then
Okay.
on Thursday we're starting at 9 o'clock.
We're going to start hearings at 9 or voting session at 9?
Voting session at 9.
Okay, for Thursday, but tomorrow voting after the hearings. Okay. Okay, thank you.
And then after we get over this hump, our schedule lightens up a little bit, so we have a little bit of reprieve.
Thank goodness.
At least in the committee. So your delegations and all the other stuff you're doing, that's on you. But okay. Sandy, did I miss anything?
No, but just a quick reminder, since we did cancel bill hearings on Thursday, they've been rescheduled to Friday, February 26th after the floor session.
And that was done in consultation with the sponsors of the bills, just so everyone knows. Okay, excellent. So we'll see you all tomorrow. Have a good night.